to Superintendent Tom Horne, our next Attorney General, and he has many topics to talk to you about, not only his history, and I know that this is an informed group. You're probably going to get some good questions here, Superintendent Horne, about the issues that we face in our state. So welcome, Superintendent.
Thank you.
Hold it a little farther away.
A little further away, is that better?
Mm-hmm. Even further.
Even further away. I'm Tom Horne, and if elected Attorney General, I will vigorously defend Senate Bill 1070, and I will join the national lawsuit. To declare Obama health care unconstitutional. Yeah. Before I go any further, I want to say that Margaret Dugan has been my deputy for a number of years, and I'm as passionately in favor of her being elected superintendent as I'm in favor of myself being elected Attorney General. She would be a fabulous superintendent. I hope you'll all vote for Margaret. I also want to introduce you to my wife Marty, who has her master's degree from the Juilliard School of Music, which overqualifies her to do what she's doing now, which is driving me around the state. You all are familiar with me as the superintendent of schools, making conservative principles work in the Department of Education, eliminating bilingual education, working with Margaret on that, getting a bill passed so we could do away with ethnic studies, and I'll talk a little more about that, which Margaret has talked about, holding our schools, our teachers, and our students accountable, and showing results. On the Terra Nova test, which all of our kids, grades 2 through 9 take, were above the national average. Scholastic aptitude test above the national average. ACT college entrance test above the national average. Not as well known is my legal background. Before becoming superintendent, I was a practicing lawyer for 30 years. I learned education serving simultaneously on a school board for 24 years and then 4 years in the legislature. But my profession was as a lawyer. I was a special assistant attorney general. I was a litigator, so I have more courtroom experience than almost anybody who works in the attorney general's office. I was Judge Pro Tem Superior Court, Judge Pro Tem Court of Appeals. I wrote a legal textbook published by the State Bar that's in its 7th printing. I taught legal writing at ASU Law School. And I was rated by my peers as an AV lawyer. There's an annual survey done by a company called Martindale-Hubbell. If you go to a lawyer and ask for a reference on another lawyer, they'll refer you to Martindale-Hubbell. And AV means, A meaning I'm an A lawyer, V meaning very ethical. I've been rated very ethical every one of my 30 years as a lawyer. And I got 5.0 out of a possible 5.0 points, which Martindale-Hubbell refers to as a preeminent attorney. So I'm well qualified professionally to be Attorney General. And I use those skills as superintendent of schools to do what I view as the second half of my job. The first half of my job is what I talked about a minute ago, raising academic standards, bringing academic rigor in the classroom, showing results on test scores. The second half of my job, which I believe is the second half of any public servant's job, is to do what I can to save the taxpayers' money. And as an example, we had a case called the Flores case. Some of you would have read about it in the newspaper, in which a federal judge was fining us $1 million a day because we were not spending as much money as he thought we should spend on English language learners. Now, I always thought that was a decision to be made by the people through their elected representatives. How much do we tax ourselves? How much do we spend? What do we spend on? Not by a lifetime federal judge who's not accountable to anybody. The Attorney General refused to appeal that decision while we're being fined $1 million a day because he and then Governor Napolitano were on the side of the plaintiff, the people who sued us. And had I not been there, the plaintiff would have had an easy time because the people who were supposed to be defending us were actually on the plaintiff's side. I was the only one who appealed the case, and when the fines reached $20 million, I got the Ninth Circuit to put a freeze on them until it got to hear the case on the merits. And in those days, I would introduce myself as a superintendent of schools and the shadow Republican Attorney General because the Attorney General wasn't defending the taxpayers and I was defending the taxpayers, and I was the one who saved the taxpayers $20 million. Well, we went on and argued the case on the merits, and again the Attorney General's office argued that the district judge should be affirmed, which would mean we would owe all these millions of dollars to the federal government. And we taxpayers pay the Attorney General's salary. So it's as though you hired a lawyer, paid him a fee, and he got up in court and said, my client should be fined. Well, happily, the Ninth Circuit agreed with me. They reversed the fines. They sent the case back to the district court to hear evidence that it had refused to hear that the kids were doing better about learning English. And when the fines were reversed, my lawyer sat down with me and he said, Tom, you can no longer introduce yourself as the guy who saved the taxpayers $20 million, because if we had lost this case, the freeze on the fines would have been lifted. They would have grown all that time before we got to argue on the merits. And if we had lost, the fines would have been not $20 million, but $300 million. So therefore, you now have to introduce yourself as the guy who saved the taxpayers $300 million. Well, we went back to the trial court, and meanwhile, the legislature passed a law attempting to comply as best it could, and it appointed a task force that worked with me. And what we did was we said the kids have to have at least 4 hours a day of intensive instruction in English. When I ran for office in 2002, as Margaret told you, we had bilingual education where the kids were taught in Spanish. And I promised to change that, and when I was elected, because Margaret had written the initiative, which had not been enforced by the prior 2 superintendents, I asked Margaret to come with me to the superintendent's office so I would be sure we would keep the promise. And indeed, we immediately eliminated bilingual education, and that was a promise made and a promise kept. But one of the problems was a lot of schools threw the Spanish-speaking kids into class without teaching them English first. So the Spanish-speaking kids didn't know what was going on in class. The English-speaking kids had their education interfered with because the teacher was distracted by kids who didn't speak English. So we said, no more of that. Before you put them into the regular classroom, keep them separate for a year and teach them English so that when they go in the classroom, they'll be proficient in English, they can compete academically, and they can soar academically if they're willing to do the work. And using this new system, we have tripled our reclassification rate from English language learner to English proficient. We're now one of the country's leaders in teaching kids English. And the legislature, thank you, and the legislature gave me the job of determining how much that would cost. The local superintendents had a convention in Phoenix, and so they went down as a big group to the Capitol, held a huge press conference, and said it would cost an extra $300 million a year to implement this new program. My department studied it, and I said, no, if we're efficient, we can do this for $40 million a year. That's what the legislature appropriated, and I saved the taxpayers another $260 million a year. Well, we then went back to the district court, lost. We went to the Court of Appeals, got a different panel and lost, and I appealed to the United States Supreme Court. And my reason for appealing to the United States Supreme Court is in part philosophical, and I need to do a little detour to tell you what I've done to bring back the teaching of history in our schools. Because I believe that people who have forgotten their history are like a man with amnesia. He doesn't know where he's been, he doesn't know where he's going, and he doesn't know who he is. And if we expect future generations to preserve our institutions, we have to teach these kids what there is in the institutions is worth preserving, which means they must know our history. And when I ran in 2002, the teaching of history had fallen to such a low level that our high school kids were not learning about the Declaration of Independence, the Constitution, the Founding Fathers, the ideas on which our country was based, because under the standards as they existed at the time, the last time they learned those things was in the 7th grade when they were 13 years old. And in world history, the last time they learned about the Greco-Roman basis for Western civilization was in the 6th grade when they were 12 years old. And so I promised to reform that. My first year, I persuaded the state board to change the standards. So now our high school kids learn about our Declaration of Independence, our Constitution, our Founding Fathers, the ideas on which our country was based, the Greco-Roman basis for Western civilization. That also was a promise made and a promise kept. And one of the things we teach our kids is that we rebelled against England because we felt that we were smart enough to rule ourselves through our elected representatives, and we didn't need a British aristocracy ruling over us. And I believe we're still smart enough to rule ourselves through our elected representatives, and we don't need an aristocracy of lifetime federal judges ruling over us. And the United States Supreme Court agreed with me. When you go to the Supreme Court, you file something called a writ of certiorari. If you win, you get to argue your case. They denied 99% of them. We were part of the 1% that they granted. We argued the case last summer, and we won it. And in an important decision by Judge Alito, he told district judges all over the country to not try to micromanage the education finance systems of the states. An important 10th Amendment victory. You remember the 10th Amendment is the amendment that says those powers not expressly given to the federal government are reserved to the states or to the people respectively. And Judge Alito went further and dealt with something called institutional litigation, which could include not just education, but prison systems, mental health systems, and so on, in which you have collusion. A governmental body gets together with a friendly plaintiff. They go to court. They have no opposition because both sides are on the same side. You remember that almost happened in our case if I hadn't been one of the defendants. And they get a judgment that requires more spending than you can get through the normal democratic process. And Judge Alito said the U.S. Supreme Court disapproves of that and made it much easier to get out of those kinds of judgments. Now, when I tell people this story, a lot of times I get a question, Tom, that's really an important 10th Amendment victory. Why didn't I read about it on the front page of the paper? The answer is, the day our decision came down, Michael Jackson died, and that dominated the newspaper. But in the Supreme Court, the name of the person who brings the case, the appellant, comes first. So it's called Horne versus Flores. And when reporters call me about the Flores case, I say, it's not the Flores case anymore, now it's the Horne case. Before I talk about my priorities, I want to say a few words about ethnic studies that Margaret had mentioned. Because the problem came to my attention when a woman named Dolores Huerta gave a speech at the Tucson High School, mandatory assembly, and she said, Republicans hate Latinos. Now you can imagine the controversy that caused. And so people came to me and they said, Horne, you got to get the schools to stop having controversial speakers. I said, well, no, kids learn from controversial speakers. We need controversial speakers, but they need to hear both sides. So I brought Margaret down to give a speech, and Margaret told the kids, I'm a proud Republican and I'm a proud Latina and I don't hate myself. And she gave a very high-level speech. It wasn't partisan. She told the kids to be skeptical of what you hear and avoid stereotypes. In the middle of her speech, kids that were part of a program called Raza Studies, it's part of this ethnic studies, Raza means the race in Spanish, stood up, turned their backs to her and put their fists in the air. And the principal asked them to sit down and listen. They walked out on their own principle. Now these kids didn't learn to be rude at home. Their parents taught them to be polite. They learned to be rude from their Raza Studies teachers. And in my opinion, it's very dysfunctional because to be a successful adult, you have to deal with disagreements in a civil way. And you can't, if you think the way to deal with disagreements is to be rude and to get in people's faces, you're going to have an unsuccessful adulthood. So I asked to see the materials. And when we talk about ethnic studies, we've got Raza Studies for the Latino kids, African American Studies for the African American kids, Asian Studies for the Asian kids, Indian Studies for the Native American kids. It sounds just like the Old South, all the kids divided by race. And at first they resisted, and they went to their newspapers for protection. A lot of you know the Tucson newspapers are very liberal, the Star, and at that time the Citizen. And so they ran 3 editorials against me, the 2 papers together in 3 days. One of them had a headline, Memo to Tom Horne, butt out and shut up. I said, well, I'm not going to butt out, I'm not going to shut up, and I'm not going to be intimidated. I have a right to see the material. So we